The meeting is recording.
Okay, thank you. We'll call our meeting to order. First business is the roll call. Manager Waller.
Present.
Manager Wynant.
Present.
Manager Bradley.
Present.
Manager Wagaman.
Present.
And Manager Preiner present. The next thing I'd like to do is ask anybody in the audience to please identify themselves. That isn't on the Rice Creek board or Rice Creek.
Alex Rexford with Artist Street is on the line.
Were you
Rebecca
able to?
Haug, City of Blaine is on the line.
Pete Moreau, Samatek is on the line.
Nick Mantle with Laux is on the line.
John Knudsen with Laux is on the line.
Okay, and that everybody that's out there has identified. So next thing we'll do is set the agenda. Anybody like to add or subtract from the agenda today?
President Preiner, staff have no adjustments.
Okay, then I'll need a motion.
So move.
Second.
Motion made and seconded to go ahead and set the agenda as presented. Any further discussion? And we'll go ahead with roll call. Waller?
Yes.
Manager Wynant?
Yes.
Manager Bradley?
Yes.
Manager Wagaman?
Yes.
And Manager Preiner, yes. Approval of the minutes?
Madam Chair, this is Manager Wynant. I move approval of the Rice Creek Watershed Board of Managers Workshop from Monday, December 7th.
Second.
You have a motion and a second. Any further discussion? Roll call will be Manager Waller?
Yes.
Manager Wynant?
Yes.
Manager Bradley?
Yes.
Manager Wagaman?
Yes.
And Manager Preiner, yes. Okay. Motion passes.
Madam Chair, Manager Wynant, I move approval of the lengthy minutes from the regular meeting of the Rice Creek Watershed Board.
December 9th?
I see Monday, December 9th, but it must be Wednesday, December 9th.
Okay. Do we have a second?
I'll second that.
We have a motion and a second. Any further discussion?
President Preiner.
Yes.
I'll just note Marcy or Manager Wynant's reference is correct. The day is wrong. Just below line 4 in the minutes, it should say Wednesday, December 9th, not Monday.
Thank you.
All right. So we have a motion and a second. Any further discussion? Manager Waller?
I assume that includes the correction of the date, so I'll vote yes.
Okay, Manager Wynant?
Yes.
Manager Bradley?
Yes.
Manager Wagaman?
Yes.
And Manager Preiner, yes. Okay, so that all passes. The next thing is the consent agenda. Anybody from the board that would like to pull out any particular permit on this for discussion, or is it all, any questions? Any questions from the board?
Nope.
If not, I'll call for a motion.
Madam President, I move to approve the consent agenda to Caprock permit number 20-102, 20-108, and 20-110 in accordance with the engineer's findings and recommendations dated January 6, 2021.
Second.
We have a motion and a second. Any further discussion? We'll call for a vote. Manager Waller?
Yes.
Manager Wynant?
Yes.
Manager Bradley?
Yes.
Manager Wagaman?
Yes.
And Manager Preiner, yes. Motion passes. Next thing on the agenda is open mic. Is there anybody that would like to comment under open mic on anything that isn't on the agenda today? Any comments from the audience? Hearing none, we are going to recess our regular meeting and convene our public hearing. Okay, So the first thing, again, if there's anybody new that has come online since the beginning of our meeting, please identify themselves. Anybody that's here since our meeting started? Okay, welcome everyone.
Garrett Munson has joined the call.
Okay, thank you, Derek. Anybody else out there? Okay, welcome everyone to the public hearing on the position of Artis REIT and the Whitewater Properties 1 LLC to realign a portion of Anoka Ramsey Judicial Ditch 1 Branch 2 for the purpose of a proposed office warehouse development at the northwest quadrant of I-35W and 85th Avenue Northeast in Blaine, Minnesota. For this hearing, the Watershed District Board of Managers is seated as a drainage authority for Judicial Ditch 1. Due to the COVID-19 pandemic, pursuant to statutes 13D-021, meetings of the Board of Managers are currently being convened remotely by video teleconference. Notice was previously provided with instructions on how to participate in today's hearing. I ask that those of you who speak in attendance remotely mute your microphones until it is your turn to speak. The purpose of this hearing is to receive comments from the public on the petition in order to inform the board of the public's concerns. Our decision on the petition is based on the following standards found in Minnesota Statute Section 103E227 and Section 103E806. For the purpose of realignment based on the engineer's report and evidence presented, will the action proposed A, be of public or private benefit, B, impair the utility of the drainage system, C, deprive affected landowners of the drainage system benefit. And for the partial abandonment, once the drainage system is realigned, will the portion of the drainage system orphaned by the realignment? A, serve a substantial useful purpose as a part of the drainage system to any property remaining in the system, or B, provide substantial public benefit and utility. If the board finds that the action will be of public or private benefit and that the answers to the remaining are no, the board will make an order to modify the drainage system as requested in the petition. In addition to the considerations stated, the board must decide if it grants the petition whether any drainage system funds are justified for either in the modification of future maintenance of the modification. Statute Section 103E227 allows the board with justification from the petitioner and in the board's discretion to determine whether drainage system funds may be used for the proposed action. To facilitate comments in today's hearing, notice of the time and location of the hearing was mailed to the petitioners, owners of the property, and political subdivisions likely to be affected by the proposed action. The board received a petition and bond from Artis REIT and the developer and Whitewater 1 LLC, the landowner, to realign a portion of Judicial Ditch 1 Branch 2 for the purpose of a proposed warehouse office development and for abandonment of the remnant or orphan portion of the drainage system if the realignment is granted. The proposed modification includes replacing the current open ditch portion of the Branch 2 with buried storm sewer as part of the realignment. The board accepted this petition and bond under Section 103E227 and 103E806 and appointed Houston Engineering to prepare the report assessing the impact of the proposed action. Houston Engineering completed its work in the field and filed a report with the board. The petition and engineer's report were made available for review at the district's offices and on its website in advance of this hearing and will be reviewed today. Please note that our proceedings are being recorded. The order of business for this hearing will be as follows. First, a presentation of information related to the petition action will be given by Garrett from Houston Engineering. Following the presentation, I will open the hearing for public comment. The board would like to hear public comments and concerns regarding the proposed action. Our decision will be based on legal requirements related to the petition action as well as the engineer's report and other evidence presented. During the public hearing, managers may ask questions of staff and consultants making presentations or commenters in order to clarify any testimony. In addition, if a member of the public asks a question and manager believes that a response from the district staff or district consultant can readily resolve this question or enrich the testimony, the manager may ask me to have the appropriate staff member or consultant speak to the question. I will exercise my judgment as to whether or not to allow the discussion. Matters expression of their positions and general discussion concerning the subject of the public hearing should be avoided during the public portion of this hearing. Board discussion will occur after all members of the public have had a chance to speak and public comment period has been closed. Board discussion may occur and be concluded at this or subsequent meeting as the board decides. Would any of the board members wish to offer any remarks or comments at this time? Anybody? If not,
Madam President, this is Manager Brad. I just had one question on page 45 of our materials, and you may have referenced it generally. There's 4 properties that were supposed to receive specific notice of this proceeding. I just want to verify that those 4 properties did receive notice.
anybody? Nick or Garrett or whoever did the noticing?
Teresa, do you know that those properties were noticed?
Yes, Garrett, the engineer provided that information, Mr. Munson, and we were mailed or emailed, if they gave me an email, the notice, both.
Thank you.
Okay, with that, we'll go ahead and turn it over to Garrett from Houston Engineering to give us a presentation.
Thank you, Madam President. Good morning, Madam President and Board of Managers. As described, we will be discussing today the petition for the partial abandonment and realignment of Anoka Ramsey Judicial Ditch 1, Branch 2, near 35W and Highway 32, 85th Avenue, County Road J, many names for the road to the south. So when we review these petitions, we're reviewing them under Minnesota state statute, and the petition has a purpose that we're reviewing it under, and that is to, as I said, realign the judicial ditch to accommodate the land development, and that's the Blaine 35W Industrial Park that was described by Madam President. We review it under the 2 different Minnesota state statutes that it was petitioned under. Minnesota State Statute 103E 227 for the impounding, rerouting, and diverting of drainage system waters. And when we're reviewing under that, we're looking at a couple different considerations. Is the proposed action of public or private benefit? Will it not impair the utility of the ditch and not deprive affected landowners of their benefits? So we're looking at the function of the ditch and whether or not upstream drainage through this property will still persist. And then also looking under Minnesota State Statute 103E 805, the partial abandonment of drainage system, determine that the part of the drainage system that's to be abandoned no longer serves a substantial purpose, benefit, or utility. So it's both and. Is the proposed action acceptable to the drainage system, and is the portion being removed no longer beneficial to the drainage system? So the portion of the drainage system that we're talking about is within the project area of the 35W Industrial Park that's being proposed under a Rice Creek Watershed District permit. This is near the confluence of the main trunk of ARJD1, the branch 2 with the main trunk. That's just to the north of the project area here. To the east of the project area is the interstate. To the south is County Road J West. And there is a service road running through the parcel. The proposed modifications to the public drainage system include abandoning ARJD1 Branch 2 open channel on that parcel and in the upstream right-of-way, and then realigning the abandoned open channel into 2 48-inch pipes along the current open channel footprint. This effectively extends the culvert that is to the east in the right-of-way and continues them downstream to the downstream end of the parcel where it discharges northwest. So this is in the northern part of the parcel that's proposed for development. We can see the footprint of the existing ditch here at the north, going from west to east or right to left on your screen. And the proposed development with the pipes is shown here. You can see the buildings proposed on site and parking structures and things. And then the pipes that are proposed to be connected to the culverts under the current plan and discharge at the property boundary to the north. So when we're looking at these proposed modifications, we're considering some design requirements, that pipe be reconstructed at the as constructed and subsequently improved condition grade or current elevation, whichever is lower. So this is to not diminish the drainage capacity of the drainage system or pose rather an obstruction to the public drainage system. No reduction in drainage function, and also to ensure that it is both constructible and maintainable. And we'll touch a little bit more on the maintenance part of this in just a couple slides. We're also looking to make sure that the proposed action has a provided access corridor. So that's so that it's sufficient to accommodate future maintenance. When we're looking at that, there's a couple different components. One is on the surface. Is the surface above the pipe free of permanent structures or features, and or if there are permanent structures or features, hard features, is there an indemnification in place, or are they able to be indemnified? Meaning, if it's a permanent or semi-permanent structure, is it a parking lot versus a building? A parking lot can be, torn open, work completed, then repaired. That's a little harder to do to a building. So we want to make sure that the maintenance is doable in the future and that there's not something like a building in the way. Then also considering the subsurface development of the parcel, is there an ability to maintain the pipe, meaning that they're not proposing water quality function either in line or above the pipe? Is there a lot of different crossings proposed under the ground but over the pipe? What consideration has been given to that to keep the right of way of the public drainage system as clear as practicable and enable maintenance in the future? And all of this would be documented in an easement over the pipes and their access corridor. So when we're reviewing the utility of the system, we're looking at there's no change in drainage function upstream or downstream, and whether or not the location of the realignment is sustainable. So that's part of the able to be maintained into the future, and is it going to be constructed in a way that isn't eminent to fail? And then it's important to note that throughout any of these public drainage modifications, the Rice Creek Watershed District, as drainage authority, maintains the responsibility for drainage system inspection. And that's consistent with Minnesota state statute. So now we're going to get into some more of the detail of the maintenance of the system. When we're looking at these factors, one of the things we consider is the conversion of the open channel to the pipe. And taking a look at that, this often results in a higher life cycle cost. While there might be some price reduction in year-to-year annual maintenance, the initial construction cost is of course high, and then the cost to replace is much higher for a pipe than for an open channel, where you can easily get an excavator in there and dip it out, remove vegetation or blockages. Whereas when there's a pipe, if the pipe fails or reaches its life cycle and needs to be replaced, then the cost to replace is much higher. Typically, the petitioners are responsible for the cost of the construction of the realignment itself. And in this situation, because of the increased life cycle costs, we're also recommending that the petitioner and future landowners be ordered the responsibility for maintenance of the pipes on the developing parcel. Just a couple notes on that. That does not mean that the petitioner cannot have Rice Creek involved in that process. Rice Creek is definitely well situated to complete inspection and maintenance activities. And it may behoove the petitioner to work with the Rice Creek Watershed District to have the Rice Creek Watershed District continue to inspect and maintain into the future, and then those costs assessed to the property. And that has been discussed with the petitioner, that the details of that process of future maintenance and or disbursement of cost, if the district is to complete those maintenance activities amongst the landowners of the parcel, is to be documented in the permitting process through the maintenance agreement and easements. through our conversation, the petitioner intends to distribute the costs amongst new parcels when the site subdivides. And as I mentioned, the details around that would be recorded in the maintenance agreement that's going to be executed through the permitting process for this parcel. But note that there is in the final findings and order around this resolution to order the realignment and partial abandonment, if that's undertaken by the board, would include language that puts some of the broad strokes or bounds on that process in place. In conversation with the petitioner, they have done something similar in many other situations where there's a small drainage area to a certain feature that any kind of maintenance or inspection cost is then dispersed amongst the landowners in the future, rather than just being borne on a single subdivided parcel that has the footprint of the feature on it. The road authority is to retain responsibility for maintaining their existing culverts in the road right-of-way. And the petitioner and the road authority are to document the responsibility of maintenance for the realigned pipes within the right-of-way, depending on how they're constructed and what's agreeable to both parties. And that would also be documented during both Rice Creek Watershed District permitting and then any MnDOT or required county or city permitting as well. So looking at the impacts and the benefits of this partial abandonment and realignment, is we're seeing no impact to wetlands or floodplains or runoff rates associated with the realignment and partial abandonment, the conversion of the public drainage system to pipe. This is not a comment on the permitting side of things, the development itself, that undergoes a separate parallel effort. But the realignment of the public drainage system and partial abandonment does not pose any impact to wetlands, floodplains, or change in runoff rates. And the benefit of the project is to accommodate development on the petitioner's property. Therefore, the proposed action does have a benefit. So the conclusions of our engineer's report, as prepared for you, show that the proposed modifications do have that private benefit. They do not impair the utility of the public drainage system. There is no notable increase or decrease in drainage function. They're continuing the capacity of the drainage system downstream from the roadway culverts under the service drive, and they are sufficient. We looked at them in our district-wide model to make sure they're not impacting floodplain and major system evaluation events like the 2 and 10 year drainage function. The proposed modifications do not deprive the affected landowners of their benefit. There's no decrease in drainage to upstream landowners. And therefore, we're recommending the Drainage Authority order the realignment contingent upon the Rice Creek and MnDOT and associated county permit approvals.
Okay, thank you, Garrett. Any of the board members have questions for the staff or the consultants?
Madam President, this is Bradley.
Go ahead.
So how will future parcel owners be made aware of their maintenance obligations and financial obligations associated with that?
President Pryor?
Yes, Nick, I do see John Kolb's hand is up.
Very
Madam
good.
President, unless Nick, you want to go. Okay, I'll go ahead and answer the question. In discussions with the petitioners, what we plan to do is have an agreement with the owner of the entirety of the parcel today that will be recorded on the entirety of the parcel, that will detail out all of those future maintenance obligations and how the costs will be distributed. We anticipate that as part of the development, the whole parcel will be subdivided. And by recording this agreement against the whole parcel prior to subdivision, then all of the future owners of lots within that development will have notice of their obligations. It will also, according to the petitioner, their plan is to incorporate this into their, I guess we'll call it a development agreement or their master agreement for the industrial or commercial park that they're proposing to develop. And if I get that wrong, the petitioner's representatives today can clarify that. But that was the content of our discussion with the petitioner in advance of the hearing today.
Thank you.
Anybody else have any comments or questions for the staff or consultants?
Madam President, this is Waller.
Yes?
So for Attorney Cole, to continue Mr. Manager Bradley's questions there, I'm concerned about making certain that there's clear language as to the district's right to be inspecting it, and that when the district finds necessary maintenance, that be completed. Since the maintenance is going to be completed by the property owners and not necessarily by the district, or if it is to be done by the district to be billed back. So that's my concern, is to make sure that language is clear. Do you have some comments, John?
Madam President, Manager Waller, the situation Manager Waller describes has been discussed with the petitioners. Our opinion, our legal opinion, is that notwithstanding the modification of the drainage system under 103E 227, that alignment remains part of the drainage system. But by operation of statute, the costs of the installation of the modification and future maintenance of the modification, because it has a different life cycle cost than what was originally established, is the obligation of the petitioner. So notwithstanding that the statute requires them to pay for it, it still falls under the management purview of the drainage authority. So it's not a matter of us finding a problem and telling the landowner to fix it, although that is one alternative. But we could find the problem, notify the landowner, go out, fix it ourselves, and then assess that cost back to those landowners. So we've discussed that in broad terms with the petitioner. We have an understanding with the petitioner that at least they understand how that process works. And we have historically, on other actions of this type, required the execution of a maintenance agreement, required the execution of an easement identifying and protecting the alignment of the modified system. And then, like we discussed earlier, the other financial obligations will be recorded so that notice will be given to any subsequent owners of lots within the development. So I think we've got that covered, but your concern as a member of the board is noted. And when we get to the point of drafting findings and the order, you will see those contingencies laid out in the order. And when you get to the point with your other hat on of approving the development approvals, you will see the more detailed documentation of all of those requirements.
Thank you, John. That's all. I yield back there, Madam President.
All right, thank you. So with that, we're ready to hear from the members.
Madam Chair,
Go ahead.
one more question here. Just
Go ahead.
I'm following along with these two comments from my fellow managers. Can you explain? So we have this Artist REIT and Whitewater Properties. Is the explain the relationship between the two, and who exactly are they both petitioning us? Who is the responsible party here?
Madam President.
Go ahead.
And Manager Wynant, both have petitioned because both have an interest, both either currently or in the future, in the property. One is the owner of the property, the other is the developer, and they have an agreement between the two entities as to that future development. So we typically require that both be on the petition. And so we are working with both entities as to these future requirements, but the ultimate responsible party is the property, not necessarily the human beings, because human beings come and go. And that's why we keep talking about recording things back on the property. So what we look at when we get a petition of this type is who has an interest currently or an anticipatory interest in the property. And we require both of them to be petitioners so that both come into everything that's happening in this proceeding with their eyes open and are able to participate in order to address their particular concerns with regard to the action of the board.
And then you had stated that once we will be getting requests for permits to actually develop these proposed buildings in the future. And at that point, we can be even more clear about what is expected of them.
Actually, Madam President, Manager Wynant, those two processes are occurring concurrently as we speak. While this proceeding is going on here, your permitting and development approval staff is working on the applicants. In this case, I think it again is probably both entities, the applicant's application for the proposed development and all of the, the stormwater management and everything for the overall development. So our intent is that these two actions are coordinated and marry up. And to that extent, we've already had coordinating discussions with your permitting staff at, back at the district office. So I hope that answers your question, but we are tracking these two events concurrently because they are related and they are interdependent.
Thank you. Thank you.
Madam
That's all I
President-
have.
Madam President, another question, if I could.
Go ahead.
So who does the actual fiscal realignment, and how do we make sure it's done to meet all of these requirements?
Madam President,
Go ahead.
Manager Bradley, the work will be done by a contractor selected by the petitioner. And one of the things that we do is we provide some inspection or verification as they're constructing the project. Typically, that'd be done by district staff to review that the work that's being done meets the conditions that we've identified and the construction plans that have been provided. So, we typically for any permit provide some inspection, but we do also provide some specific inspection to the petition as well to ensure that it meets the requirements.
Do we have any approval role in approving the contractor?
No.
Is that a concern?
No, it hasn't been a concern to date in any of the other previous petitions that we've dealt with.
Any further questions from the board?
President Preiner,
Go ahead.
if no other manager has a question, I do have one or two comments. I think we touched on the fact that Manager Bradley's question, I would see it as a stipulation of the permit itself and likely a condition of the order to inspect the system that may include televising of the system as it was built to ensure it's consistent with that plan set. I think that would be the optimal way to identify its condition. Secondly, I would like to ask Mr. Kolb in regards to the recording and the allocation, if you will, of the future potential costs in the maintenance or that type of work. And how has it been contemplated how that might be distributed? Would it be based on land area or this sort of thing? I realize it's a detail that maybe I'm jumping ahead here, but I don't think the district would be comfortable to say although all the parcels of a future subdivision benefit, 100% of the cost would be on a single parcel and the rest would be zero. So there must be some metrics that would be put in place to distribute it in a rational way.
Madam President, members of the board, in answer to Nick's question, we typically give the applicant the egg and don't tell them how to suck it. And so pardon that analogy, but that's the goal here is to protect the interests of the district and the drainage system. And our primary concern here is that all of the obligation is not placed, for example, on an outlot that is, either non-income producing or there's no real human being there to address it. So the discussions we've had with the applicant and the developer, the owner and the developer, is that we are going to record this obligation against the entire parcel. And then within their association plan or their development plan or their association agreements, if they have a master agreement, they need to distribute that on some sort of pro rata basis against each of the occupied lots within the development. And we can, those are discussions that we're having with your permitting staff to make sure that that is clearly articulated in those approvals. And it is a line item that we would intend to put in some of the contingent requirements of an order resulting from the proceedings today.
Any other questions? Okay, with that, we're ready to hear from members of the public who wish to comment. But before we take public comment by these participating remotely, I ask that any written comments to be read into the record at this time. Mr. Kolb, I believe you have written comments.
We do have a written comment, Madam President, from the Department of Transportation. Just give me a moment to pull that up.
Sure.
And just like that, Madam President, I've got a computer issue trying to pull that thing up. I should have had that teed up here before we started. If you want to move on to, if there's something else we can, unless you have it, Nick, and then you could read it. It is from Beth Noondorf at MnDOT. Thanks, Nick.
You bet. President Preiner, I might also mention before I do this, maybe Garrett, if you want to stop screen sharing, thank you. So email from Beth Neuendorf, State of Minnesota, MnDOT, January 11th, 2021, 3:22 p.m. As follows. I have the following comments on the ARJD1 partial abandonment and realignment. Leave the existing apron outfalls as is on MnDOT right-of-way so that MnDOT has access to the culverts under the I-35 service drive for inspection and lining repair. Put the pipe system apron inlets on the private right-of-way side instead of connecting directly to the MnDOT system. If this is not possible, then place manholes at the ends of the existing culverts and have the pipe system start from there. The salvaged aprons are the property of MnDOT. The developer will need a drainage permit from MnDOT. The plans require review and approval prior to issuing the permit and prior to any work on MnDOT right-of-way. Beth Neuendorf, District Water Resource Engineer, MnDOT, Water's Edge.
Any other comments from the public submitted?
Staff have none.
Okay, then we'll go ahead to the members of the public to participate remotely. Please identify yourselves before you start speaking and just unmute your microphone, speak clearly and state your name and address for the record and make your comments. If you have a specific question concerning the proposed realignment and the partial abandonment of the public drainage system, we may ask our administrator, engineer, or legal counsel to respond. If you have anything else you'd like to submit in writing, you may contact the district office and make arrangements for its delivery. To ensure all wishing to comment on the proposed realignment and partial abandonment of the public drainage system have time to speak, I may limit the time of each speaker up to 5 minutes. Please limit redundant or repetitive comments. Once we have heard all who have signed up to comment, I will open the hearing to additional comments. Since I don't have a list, we're just going to go with whoever wants to speak, please speak clearly and identify yourself. Go ahead, the public. Anybody from the public that'd like to speak on this issue? Anybody out there that'd like to speak on this issue for this hearing?
Chair Priner, this is Rebecca Haug with the City of Blaine.
Okay.
Address 10801 Town Square Drive, Blaine, Minnesota 55449. Just want to state that the city has reviewed this application. Our biggest concern is to make sure that the applicant is aware of their responsibilities to maintain this pipe once it's in. The city does have other areas where ditches have been piped and have had a lot of maintenance issues with that over the years. So just want to make sure that those things will be taken care of by the applicant. Thank you.
Thank you, Rebecca. Anybody else that'd like to comment, please identify yourself and speak. Any other comments? Anybody else like to speak? Okay, so I think there is no more general public that want to speak. So hearing no further testimony from the public, I close the public comment portion of the hearing. So we are now closed, and I guess at this point we discuss the recommendations. Nick, you're going to lead us through that.
Madam President, before you do that, can I follow up on the DOT question? How will the DOT's concerns be addressed? Through the permits?
Madam President, Manager Bradley, what 103E 227 does state a requirement that the applicant receive all other required permits before proceeding. So we're noting that there is concern of the DNR about a direct connection between this rerouted drainage system being put into storm sewer and then a direct connection to the culverts that run under the road or transportation infrastructure. And what we have encouraged is a meeting between the applicant and MnDOT to work through those issues. At the staff level, we had already identified this concept of having inspection ports on the private land side of the right-of-way and then onward, or to leave an open gap for the purpose of inspection and maintenance of the other public infrastructure that's downstream of this realignment. Those details have yet actually to be finalized, but in your order, it will be very clear to state that, number one, this concern has been expressed, and that number two, it is the applicant's obligation to coordinate with and receive all other permits that are necessary to execute the activity authorized in your order, if you so choose to authorize the modification.
Madam President?
Go ahead.
So just for clarifying here, John, Manager Bradley asked about the DOT and you said DNR, but you meant DOT. Is that not correct?
You know, I've got all those acronyms swimming around in my head. Yes, Manager Waller, that is correct. I meant MnDOT, not DNR.
I just wanted to make sure that was clear. I don't have any other. Thank you very much, John.
Okay, any other discussion by the board?
Madam President?
Mm-hmm.
And just to follow up one last thing on that item. So going on with what Attorney Kolb was saying about the dialogue between the applicant or a petitioner and the DOT and how that might change the connection point. Regardless of all that, how that happens, it will not change the utility of the system or the opinion of the engineer on the efficacy of the application, or I should say the petition itself. So whether it is connected directly or there's that gap or they construct a manhole, in all cases, it doesn't change our opinion on the viability of the application and our recommendation.
Thank you, Chris. Anything else?
President Preiner,
Go ahead.
I would note informal discussion I had with staff at the City of Blaine and to the meeting that Mr. Kolb noted, MnDOT and the Rice Creek and the petitioner. It might be good to, at a minimum, invite Blaine to participate in that. The reason being, it was suspected that this portion of the road may have been turned back to the city by MnDOT. Of course, this paperwork and type of activities take a fair amount of time, but we would want the proper individuals at the table to discuss the matter.
I agree with that. Anybody else? Comments? Okay, we're going to go to the recommended action.
Yes, President Preiner, Board of Managers, notably, this is coming to a conclusion of something we've explored with you in these larger pipe systems, and we're obviously putting the pieces together for a good order, findings and order. That will take a bit of time, noting the meeting between the parties. And we would suggest also noting in these COVID times that you do leave the record open. The date I would suggest is January 20th. That gives it time for anyone else to submit something to the district and time for the meeting to take place and the development of what these materials look like down the road so that they can be properly identified in the findings and the order. We could hold the meeting over until February 10th is your first meeting in February, in which you could consider that findings and order. There is a recommended motion within the script that was provided, and those two dates could be inserted, but we're happy to discuss any alternatives the managers may have.
Madam Chair, this is Manager Wynett. I move that we leave the comment period open for the receipt of written comments as indicated in the hearing notice through the close of business on January 20th, 2021, that barring any comments requiring further inquiry, we direct staff to prepare findings and an order consistent with the proceedings, including response to all comments received through the public comment process. That the draft findings and order be written to affect the realignment and partial abandonment as petitioned and as recommended in the engineer's report. That the order and authorized modification of judicial ditch number 1, branch 2 be conditioned upon the petitioner's execution of certain easements and maintenance agreements related to the modification, and that we recess this hearing to the board's regular meeting on February 10th, 2021 at 9 a.m. or by adjournment to an appropriate time on the board's agenda, at which meeting we will consider findings and an order for the proposed realignment of a portion of Anoka Ramsey Judicial Ditch 1, Branch 2, and abandonment of the remnant portion of the drainage system.
Wow, I'll second that.
Okay, we have a motion and a second. Is there any discussion? I guess my only question is that enough time for our staff to do the necessary meetings and completion? Staff is confident?
I would believe staff is available. I would defer to Chris Otterness and John Kolb if they have any additional input.
Madam President, from our end, we don't see any concerns or issues with that. And again, we are still following a parallel process and evaluating the permit as well. But in either case, I don't see, from an engineering standpoint, concern. I think the bigger concern would be for Attorney Kolb if he has adequate time to prepare the findings in order.
The short answer to that, Madam President, members of the board, is we believe that's adequate time. Again, I apologize for the farmyard analogies, but for the applicant, there's a little bit of chicken and egg going on here because I'm sure that they want to have some assurance or certainty as to how this proceeding is going to resolve before they rush headlong into the drafting of a bunch of other documents that are related. So we will make the order with sufficient contingencies as to its effect to ensure that those other processes occur in the manner that we anticipate they will, as a contingency or a condition of the authorization to modify the system. So I think we have adequate time. And if it doesn't marry up perfectly, we have some wiggle room in there to make sure that it does.
Okay, thank you. Any further questions from the board? We have a motion and a second. Any further discussion? We're going to call the vote. Manager Waller?
Yes.
Manager Wynant?
Yes.
Manager Bradley?
Yes.
Manager Wageman?
Yes.
And Manager Priner, yes. Okay. We're going to recess the public hearing and move to our regular meeting. Thank all the participants out there. Okay, first thing is recording board action, Ramsey County Inspection Services. Terrence?
Good morning, everyone.
Hey.
Madam President, Board of Managers, for your consideration. Oh, wait.
Might as well give them a second here.
Yeah.
They don't want to hear the whole meeting.
Madam President, Board of Managers, for your consideration today is a 2021-2024 inspection service agreement with Ramsey County Parks and Recreation, Soil and Water Conservation Division. This can be found on the drafted agreement can be found on page 63 of your packets. I just want to note, over the years, we've had a great working relationship with Ramsey County with regard to inspection services. I believe this agreement, there's been a few different terms, but it's been going on since 2012. Let's see. The notable changes compared to the last agreement term, the last agreement term was from 2017 to 2020. Just some slight notable changes. Ramsey Conservation District is no longer Ramsey Conservation District. It is now, they have become a part of the Ramsey County Parks and Recreation Department. So there is some adjustments with the name change there. And then within the agreement, they did request a slight increase in the inspection rate. Although there is an increase, it is still low compared to what they probably could charge us for inspection services. And yeah, with that, I'll leave it open to any questions. I don't know, within the memo, you can see the general gist of everything in the area that they are currently assisting us with inspection services. So,
just a quick question, Terrence. Are the services that they're providing the same as they've always been, or has there been any increases during the years because things have changed or updated, or is it just pretty standard? I guess.
Yep, Madam President, there's no changes over the years. I think back in, let me pull up my spreadsheet here, but back in 2018, I think, was the heaviest year for hours wise, and they were assisting us with inspections, with a variety of inspectors being pulled to other projects within our district. So that year there was a slight increase in the hours that they provided to us, but in general there's nothing really that has changed over the years.
Okay. Madam Chair, this is
Go ahead.
Terrence, is this the only agreement like this we have with the county, or is there a similar agreement with Anoka and Washington County also?
Madam President, Manager Wynett, this is the only agreement that I believe we have in place with the county. I can't speak to how this got started back in 2012 because that was before my time. But like I said, they've been great partners over the years. We have a monthly inspection team meeting and they attend those meetings, and we talk about different projects or questions that they might have about specific permits. So yes, this is the only agreement that I know of that we have in place with the county.
Thank you.
President Reiner.
Go ahead.
I can confirm that the district only has currently one contract for inspection services, and that is with Ramsey County. We have had a contract or a task with Houston Engineering in the past for inspection services. We do have some ebb and flow and movement of staff to other projects or just large swings in development volume and so the permits. It's notable that it's not definitively only permits. There could be a report of a concern on the landscape, and we would ask Ramsey County folks under this contract to go investigate a little bit and report back to the district. So it's a little broader than just, specific to a permit that the district has issued. Terrence made note of the high point when we did have a larger volume of permits, but notably they've always been below the cap in the number of hours, 800, I believe it is, Terrence.
Yeah.
Yep, and always, dare I say, significantly below that. So we do have room there.
Okay, we'll need a motion.
Madam President, it's Bradley. I move to authorize the district administrator to sign the inspection service agreement with Ramsey County SWCD for the years 2021 through 2024, an amount not to exceed $44,000 per year, and on advice of counsel.
Madam President,
Yes.
I would second that if my fellow manager and colleague would change that language in his motion from SWCD to Parks and Recreation.
I absolutely agree to that amendment.
Okay, so we have a motion and a second. Further discussion. We'll call the vote. Manager Waller?
Yes.
Manager Wynant?
Yes.
Manager Bradley?
Yes.
Manager Wageman?
Yes.
And Manager Kreiner, yes. Motion passes. Hey, we're check register.
Thank you.
Madam President, I move to approve the check register dated January 13th, 2021 in the amount of $133,451.74 prepared by Redpath and Company.
Second.
We have a motion and a second. Any discussion? Hearing none, we'll call the vote. Manager Waller?
Yes.
Manager Wynant?
Yes.
Manager Bradley?
Yes.
Manager Wageman?
Yes.
And Manager Kreiner, yes. Motion passes. Okay, items for discussion. Fund 10 General Administration Balance. Nick, I believe that's you.
Yes, President Reiner, Board of Managers. We recently had our annual audit kickoff meeting where the treasurer as well as staff and the Redpath crew meet to discuss the audit ahead. We had noted that the district's Fund 10, which is our general administrative activities, is likely to exceed the budgeted amount for 2020. Each year, we set a reasonable amount for what we think inflation and other matters in our past use and forecast amount for the year ahead. The final invoices are still to be seen for this year. But it does appear that we are going to exceed what we've budgeted for this fund. I'll share that it's in the neighborhood of less than $10,000. The overrun is attributed largely to the pandemic, COVID-19, and other unplanned events that resulted in additional board meetings and these administrative activities. We have consulted on the matter, obviously, during that meeting and in the best way for us to address the matter. It's staff's intent, as well as your consultants, to offer you the utmost transparency. And so we're doing that now just to let you know of the matter. And we will continue to work with Redpath and your council as well to bring forth what I'm believing to be a simple motion, just asking you to recognize it. And that way, going into your audit and those final papers, it is noted that we've addressed the matter. So that is my informational item on that.
Any
The only,
questions?
Madam President, the only thing I would add is that we are following Redpath recommendation on that, on what they considered to be proper accounting practices. So
Yes.
we're not doing anything out of the ordinary at all. I mean, that was their recommendation.
Right. President Preiner, just to advance that thought, that Redpath was, this is unremarkable, or if that's the proper term, it's not uncommon for it to occur. And certainly with COVID-19 pandemic, they are seeing this across their other clients as well.
Okay, thank you. That's just for information. Any further discussion from the board? Okay, we're going to move to district engineer update. Any questions for the engineer on any of his updates? Anything new, Chris?
Madam President, nothing to report other than what's in the engineer's report.
Okay. Any questions for Chris? Now we're going to move on to administrative updates. Nick?
Yes, thank you, President Preiner, Board of Managers. I do have a few updates here. One of which is in regards to, you'll recall that Circle Pines raised a concern in the courts as to Anoka County's interpretation of Watershed District Manager appointment, the statute related to that. And the court found that Anoka County had acted consistent with its authority. However, recently it's come to our attention that Circle Pines is appealing that decision by the courts. And this obviously does concern all watershed districts. Notably, it's our watershed that's in the mix under Anoka County here in their appointment process. And so Rice Creek here may want to consider notifying MAUD as to this situation, as they are, the entity agency that supports all of the watershed districts in the state. Certainly, Lewis Smith is online, and I think having a dialogue on the issue with him may be appropriate at this moment. And then when we return, I have a few more items.
I would like to address Lewis for a second. Lewis, is there any way that we as a watershed board can participate within this? I mean, last time we really didn't have anything that we could say. I'm just wondering if there's more that we could be doing. Go ahead.
Madam President, managers, at this point, the appeal has been filed, and the two parties to that appeal are the city of Circle Pines and Anoka County. The possibility exists for parties that are interested in this either to seek to intervene in the appeal or to file and obtain the status of a friend of the court or amicus. I would note that there's deadline issues. The petition for the leave of the court to get the amicus status has to occur within 14 days of the appeal, which was yesterday.
Wow.
It is not unusual for the court to receive a petition after that deadline, and it's with the court's grace, the deadline can be extended to allow a party to seek that status, and you would typically explain the tight occurrence over the holidays and notice of the appeal in your meeting schedule. I also happen to note that the Board of Directors of MAUD is meeting this afternoon. And so it would be timely if you wanted to notify them of this appeal and their potential interest in being an amicus. I would say that if they do, that they'll address the interests of the metro area watersheds that are at issue under this statute in terms of the appointment process. I am not super confident of the ability of the district at this date to seek to intervene in the appeal. That's something that could be explored.
Madam President, it's a tough question whether or not we should seek to be a party. I certainly think MAUD should take a position, and if they did, I would think we could join their amicus position. Normally, we don't have a role in deciding who gets to sit here. I mean, other than to make sure we provided legal assistance so that they could know what their rights were. And in that sense, I would not be opposed to us filing as an amicus to inform the court, because that's what amicus does. Amicus role is not really to take a side, but rather to assist the friend of the court, assist the court in understanding this. And for that reason, as I work my way around this thing, we could reasonably seek to file an amicus to be a friend of the court to help them understand this process, much as we assisted the county.
Okay.
Is this being heard in, is this an Anoka County court? What's?
Madam President, Manager Winan, it's the Minnesota Court of Appeals.
So I guess, Madam President, I'd suggest that we first of all start off by asking Lewis to this afternoon to talk to MAUD and see what their interest level is. And if there isn't an interest level, bring it back to us to decide whether or not we want to separately file an amicus brief on this.
And how would you like it to be brought back? Just as email or notification or another board meeting, or what would we like? I think we have to follow through on this.
Yeah, I think we'd have to. What we could do is we could take action now
to allow him to go ahead.
To allow him to go ahead and do that, and then he could advise us after today's meeting.
Would you like to make a motion to that?
Yeah. Okay. So let me.
As you got the answers, let's go.
Yeah. So I would move that we authorize Lewis Smith to first of all inform MAUD of this and encourage MAUD to take a position to inform the court as an amicus, a friend of the court, and that if they do so, that we join that in support of their amicus action. And if the MAUD declines to do so, that we go ahead and file a notice, because all we have to do is file a notice and a statement of our interest within 14 days. That we independently then, if necessary, go forward and file a notice of intent to file an amicus. That's all that was required in the 14-day period, if I'm not mistaken, Mr. Smith.
Correct, Manager Priner. And again, with the deadline having been yesterday, there'd still be a request to extend the deadline. So I do understand the motion.
Okay.
I would second that. And then a question, the deadline expired yesterday, or you just received the information yesterday and we still have?
That's what I was going to ask.
I learned, Madam President, Manager Winan, I checked the court's docket on, I believe it was either Friday or, yeah, it was late at the end of the day, Friday, and learned yesterday that the 14-day deadline was yesterday.
Oh, okay.
So
So it is a matter of asking the leave of the court. We conferred with the clerk of court about the situation and the deadline, and it's not unusual for a party that learns of an appeal wants to seek amicus status to seek that after that 14-day deadline has passed. But so we'll follow up as you direct if the board motion passes.
Madam President, may I just ask a procedure question?
Sure.
How are you supposed to find out about this deadline, or how do you know to file or even know it's going on in order to do this? I mean, how did, if we didn't even.
How did we get behind the 8 ball?
Yeah, exactly. How come we're past the 14 days and we don't even know that they're doing it? That's just my question, a procedure question on the courts. I don't understand how that works. I would think somebody be identified if they're involved or something.
Madam President, Manager Wegeman, well, the Rice Creek Watershed District obviously had an interest in the legal action that was decided in the district court in the sense that it was appointment to the Rice Creek Board, but it was not a party to that lawsuit. And so when the city of Circle Pines decided to appeal, all it needed to do was file that appeal with the court, which it did within the deadline they had to meet. And they did it at the very last days of December, I believe the 28th or 29th. And they were not obligated to notify the Watershed District. They did notify Anoka County.
Okay.
And as a result, we happened to just be checking the court's docket and came across this.
So Steve, to answer your question based on my past personal experiences, is if you had something that was major importance, you'd be trying to track it, and you would have had discussions before. You would have been trying to line up amicus if you're the county and you wanted it, sort of thing. And
sure.
So you're kind of sitting there just pen in hand, ready to go. That there's no reason why I would have ever anticipated that they would have appealed that decision. I mean, that's to me, that's a waste of taxpayer money.
Well, speaking of that, I'd like to ask maybe Louis, would this have been done in a closed session, or would it have to be on the record for the people to know they were paying tax money for this stuff? In other words, would this vote be taken closed so that their public doesn't know? Or is it taken open so that the rest of their community could know what's being spent on this?
Madam President, what I would say about that is that it certainly is appropriate to have a closed discussion to discuss litigation strategy with the attorney and have a discussion about the merits of an appeal and all the considerations. I think if I were advising the Watershed District about that after having such a closed session, what I would recommend is that you go into open session and by an open motion adopt the decision to pursue the appeal. I can't speak for how the city attorney in Circle Pines handled that.
But at some point they have to reveal to the public that they're in this lawsuit, right?
Yeah, now it's public knowledge.
Yeah, okay. Interesting. Okay, well, we have a motion and a second. Any further discussion? We have roll call. Manager Waller?
No.
Manager
Madam
Winan?
President, I vote no on this because I feel an amicus brief is a friend of the court, and although it's been described as something that's somewhat neutral, no brief is ever neutral. And so since I don't think that an amicus brief, and since we weren't asked by the county of Anoka to help out, I don't believe it's for us to be involved.
Well, let me ask Manager Waller this. Did you know about this?
No, it's all news to me.
Okay.
I had no idea.
Okay, Manager Waller? Go ahead. We're really in court. Hold it, we got to finish. we have to finish our vote. Manager Wynant.
Well, yes, but then there's that motion is to inform MAUD. First step, encourage them to do an amicus. If they don't want to, then it would be, the motion says that the Rice Creek Watershed would do so.
That is correct.
So it's 3 parts. So yes, I vote yes.
Okay, Manager Bradley,
Yes.
Manager Wagaman,
Yes.
and Manager Priner, yes. So the motion will pass. And we would like to hear back from probably Nick as to what transpired then with the attorney.
Sure.
We'll keep you posted.
All right, thank you.
President Priner, just a point of clarity for Manager Wynant's question, the district would take action. I think it could. You'll be apprised by Lewis of what MAUD's response is and the other parameters, and then make a subsequent decision, I would say, on that. So.
Thank you.
Okay.
All right. Couple more items, managers. One is that we did enter into a task order with Houston Engineering that was for review of the stormwater grant applications from our member cities. This is an annual event. There is an article that Rice Creek staff drafted that will appear in the Circle Pine newsletter. It's about public drainage systems. We want to be transparent with those citizens that are along Anoka County Ditch 5362, and we're working on the development of the plans to do that work in coordination with the city when they undertake a road project here in the year ahead. So we want to be providing information to the public, and obviously we'll have additional public hearings and public informational meetings as well. Another update would be regarding the Washington County Board. We did mention the meeting on the 19th of January. It's my understanding from Lewis that this will be a discussion item at the board and not a hearing. So that is our understanding of what will transpire on the 19th. But we will be noticing that the Rice Creek Board may assemble for that and be present. So you're welcome to do so.
Madam President, a follow up. I also, after our discussion at workshop, sent an email to Mr. Kevin Corbett, who's the administrator, asking whether or not they would desire for me to be present in case they had questions, and if so, if I could appear virtually. So I've not yet heard back from him.
Okay, wait, let me ask Lewis something then. Okay, it's not a hearing on the 19th. If they proceed to a hearing, are we allowed to have the public comment?
Madam President, I would say that's within the discretion of the county board. My understanding is next week they're simply going to have a discussion about how they want to proceed with this matter. And they could decide anywhere from deciding not to take any action then, or to proceed with some kind of hearing. And if they decide to proceed with some kind of hearing or further meeting or discussion of the matter, I think it would be within their discretion whether they wanted to receive testimony from, the general public or constrain it in some way. I don't think there's any specific further law other than that there should be a hearing. I would say it is also, as a legal matter, probably within the rights of Manager Waller to have an opportunity to speak if they decide to take up the matter further. So
Yeah,
I would expect that if they do, that then they would take testimony from other interested parties.
Because I've had a lot of people ask me if they could testify, so I just want to make sure at what point I can tell them that would probably be available to them.
Madam Chair,
Yep.
just a follow-up from our conversation on Monday regarding per diem. If Manager Bradley is requested to present. We said that it's very appropriate for him to receive per diem. The rest of us would be just listening in and not eligible for per diem. Is that what
That's my understanding.
All right, just to clarify that.
Okay, Nick, anything else?
Yes, President Preiner, and I hate to dwell here too long, but it has now become a little bit unclear for me. What the comment didn't cover on the per diem is Manager Waller. I would think if in his comments to the Washington County Board, he would also be eligible for per diem. Maybe not. Again, we don't have a definitive policy on this. It is district business. Could you answer to that, Board?
I decline to take a position on that. If he asks for it, pay him.
Well, he's causing the meeting. When I made the comments and proceeded with meetings, I didn't charge the board per diem because it was regarding my own situation. So everybody can do what they want on it.
Yeah.
Okay. Thank you for that.
For you.
In the middle of the workday, these types of things come up, and
Yep.
sometimes we end up scratching our heads. So better for me to ask and than not. So thank you all for that. One last item, January 27th, we have our board meeting in the morning, but in the afternoon, we do have the workshop with Erica Garms. I sent out the invite. It has a link to the virtual meeting and such. So that's everything that I have. President Preiner, Board of Managers.
Thank you, Nick. Anything else? Manager update. Manager Waller.
Nothing.
Manager Winan.
I have a few items here. First of all, I'm curious, did that amphibian drainage ditch digger complete its job in record time? How did that all go? And how many of you actually saw that monster?
Madam President, Manager Wynant, so yeah, they completed the work that we asked of them on GD2 branches 1 and 2. By all accounts, it was successful work. It doesn't mean that we're completely done in that area. We still have some work to do on branch 2 and clearing some trees and doing work to the south of County Road 8. But the work that we did do on there was of great value, and particularly getting branch 1, which is the one that goes by Goodview, done. Now we know that the channel is not going to be the problem, at least at the moment. We'll have to monitor in the future for any continued beaver activity in the area that might be blocking the channel up. But for right now, it is flowing down into the lake. And so I think it'd be a good time to notify the city of Hugo that we have addressed their concerns that they had originally brought up. And which is the reason why we actually got into doing that work in the first place.
President Preiner, I'll just note that we did have dialogue with Hugo going into it, and they were kind enough to allow the use of their property to access the locations. There was visual representation where the water line is on the cattails, that there was roughly a 1-foot water drop on that ranch 1 that came from Ashley Ritchie when she was out on site.
Good. Quite an effort. Thank you. And then the other thing I would note is that the Citizens Advisory Committee, when we talked about the Ramsey County Park Department, they have put someone on the Citizens Advisory Committee now. So those partners are on that. And then I also note that there is an opening in all 3 of the counties for another citizen. So Nick, maybe we could have a presentation about that status and how we might be helpful, because I would really like to see that committee filled out, and whatever we can do to help with recruitment, I think would be helpful.
Certainly, President Preiner, Board of Managers, we can certainly have a CAC informational update on recruitment, the efforts that are being undertaken to fill those in any way that the managers themselves may be helpful in that endeavor.
Thank you. That's all I have.
That's all? Okay.
Yep.
And anybody else? Okay, so that's Manager Wynant. Manager Bradley?
Nothing.
Manager Wagaman? You're muted, but I assume it's nothing? Okay, and for me, I have nothing new, so I'll entertain a motion to adjourn.
And it is nothing. I apologize. It wouldn't come off mute. I don't know what I was doing. Sorry.
Okay, we have a motion.
I move to adjourn.
Second.
Okay, we got a motion and a second. Any further discussion? Manager Waller?
Yes.
Manager Wynant?
Yes.
Manager Bradley?
Yes.
Manager Wagaman?
Yes.
And Manager Preiner, yes. Motion to adjourn. We're closed for the day. Thank you, everybody.
Thank you. Steve, have you gone to get cash?
I did actually. You know what? I figured if there's